Good afternoon, folks. Welcome. According to this, we have 6 hours of argument time. I'm not good at math, but that takes us to 8 o'clock tonight. I'm not so sure everybody wants to hear me that late. So I ask that you ask for the time that you need. We have read your briefs. We have read the record, and we're ready to go. So that said, first case up, People versus Isaac Resto. Okay, that's submitted. I don't know. I didn't scare somebody off. Link LLC versus 170 East End.
Good afternoon, Your Honors. Dylan Newton on behalf of the appellant Link 1 LLC. We'll be requesting 10 minutes for our argument and 5 minutes for reply.
Okay. Okay, 5 and 3 and 5. Thank you. You know, we really actually did read your briefs, but anyway. Daquana S. versus Jeff M. That's submitted. 711 East 13th versus the New School. You're here by yourself? Oh. Do you wish to submit, or? Okay. Yeah. All right. Thank you. Okay. Number Small versus DMJ Group. Yes. Yeah. Oh, there you go. Yes. How much time?
7 and 2, please. 5 minutes.
Who are you?
Sorry.
Okay.
Sheila Shen for the responsible
So you're together, or? So 5 minutes, right? Okay. 5 and 3 and 5. People versus Nasheen Bartel. That's submitted. Number 7, Camelot Event Driven Fund versus Morgan Stanley.
Good afternoon, Scott Musoff for appellants Morgan Stanley, Goldman Sachs, 7 and 2.
Okay.
Your Honor, representing separately 14 other underwriters, starting with JP Morgan, we request 4 minutes.
Okay.
John Mazzio Hamilton, Bernstein, Lewis, Berger, and Grossman for the respondents. I would just request an equal amount of time.
You mumbled that. You mumbled and trailed off.
7 minutes.
You want 7 minutes. All right. This has to do with the PSLR, right? Whether or not it applies or not, right? All right. So you represent the Morgan Stanley folks?
Yes.
Okay. I'll give you 5 and 3. You represent the Wells Fargo's folks? No.
I represent JP Morgan, Citi, the 14 of my clients.
Okay. 4 minutes. Okay. You get 4 minutes. And then I'll give you 5 minutes. Okay. Right. So we got 5, 3, 4, and 5. Got that, Gerard? Good. All right. NYRCA versus James.
Appellant request 7 and 3.
All right, this is the joint bidding issue, correct? 5 and 3 and 5. Just so you also know, whatever time I give you, if we are still asking questions, don't worry about it. You know, we'll keep going. Mato versus Franklin and Plaza Apartments.
Plaintiff appellant, 5 and 2, please. Respondent, 5 minutes, please.
Okay, 5, 2, and 5. Thank you. Cheney versus Fulton Jefferson Housing.
Jeffrey Manhattan, 5 and 2, please. Respondent, 5 minutes, please.
5, 2, and 5. Thank you. Did I? Hold on a second. Oh, I'm very sorry. People, that's why I have wing folks. People versus Rudolph Moore.
For appellant 3 and 1.
3 and 1.
John Bislar for the people. I'll request
3? Okay. 3, 1, and 3. Thank you. We got Cheney already. JD2 Realty versus EvoJets.
Good afternoon, Your Honor, for appellants 5 and 2.
5 and 2.
Respondent, EvoJets, 5 minutes.
5.
Good afternoon, Jill Pizzol-Nerowitz for defendant respondent Myjet Saber 3, please.
3. Thank you. 5, 2, 5, and 3. Thank you. Navaro versus University Avenue.
Matthew Corcoran for defendant appellants. Can we get
5 and 3?
Respondent, George Ilkert, 3 minutes.
3 minutes, thank you. 5, 3, and 3, thank you. Patterson versus City of New York.
Patterson appellant, 9 and 6, please.
Huh, I'm sorry?
9 and 6.
9 and 6, there's nobody here. Do you care to submit or you want to argue? All right, 5 minutes, sir, thank you. People versus Isaiah Martinez. Let's submit. Foster versus Snow. That's a non-enumerated. And Das versus Dormitory Authority. That's also non-enumerated, so we're good to go. All right, thanks very much. All right, first case up is Link LLC versus 170 East End. That wasn't too bad. Okay.
Thank you, Justices. If it may please the court, the trial court in this case...
You need to tell me your name, who you represent.
I'm sorry. My name is Dylan Newton from Archer and Griner. I represent the plaintiff appellant, Link 1 LLC.
The owner of the unit,
The
right?
owner of the unit, that's
Right,
correct.
Thank you.
If it may please the court, the trial court erred in this case by denying appellant's motion for partial summary judgment on respondents' liability for their decades-long failure to maintain the common elements. Now, there are 3 undisputed problems with the common elements, any one of it which would be sufficient to establish summary judgment.
Well, correct me if I'm wrong, but doesn't the record here have many experts on both sides as to the cause of the mold and the water infiltration into the unit?
Justice, there are many experts on both sides, but if we look through the records for a motion for summary judgment, it's only material facts that will defeat it. The experts are actually concluding that the problems there's certain problems that are undisputed. For example, with the 90-degree pipe, there's a 90-degree
Well, no, that's where I think Chubb came in and took apart what the defendant said that they did. They remedied, they claimed they remedied it, and then Chubb came in and did it on their own and did something to it, like took it apart and then put it back. And that's where they're saying that the plaintiff never told them that that was going to happen or that happened. I mean, that's one claim that they're, unless I'm reading it wrong, I thought that that was one of the arguments they made.
And just to address that point, Your Honor, so there is an allegation that that respondent raised in their respondent paper, in their opposition papers, and that was that the pipe insulation was cut. However, even and if you go through that, you'll see that that representation, which was made by the property manager, it's unsupported by any photographic evidence, it's unsupported by anything. But even taking that aside, the experts in this, the one issue that the experts are in agreement is what's contributing to the problem with the pipe is elevated moisture levels in that ceiling plenum, which under the bylaws and under the offering plan is the respondent's responsibility, and that is causing moisture to accumulate on that pipe and causing mold to accumulate on the pipe as well too. And you can see that in respondent's expert, Langen Engineering, back in 2013, when it spoke about how the
Counsel, even if you made out your prima facie case, what about all the HVAC evidence that the defendants provide?
But again, the HVAC system, again, there are allegations that the HVAC system was misused, but it does not change that the ventilation system has not been providing proper ventilation, which is contributing to the moisture and mold that's accumulating on the pipe and mold throughout the unit.
So I piggyback on the questions of my colleagues. There's a lot of information here that's very technical. There's some agreement there's agreement that there was water coming down the walls, there's water coming from the ceiling, there's agreement that there's a gap am I correct, between the building facade, it's an issue with the, and the actual interior, there's a flashing issue, but are these questions more properly posed to a jury as opposed to having them decided on paper?
Your Honor, we would submit, as you very correctly pointed out, the issues with the facade, there's photographic evidence of gaps in the facade. And so there's no dispute that the facade is an issue of, is the responsibility of the respondent under the condominium bylaws and under the offering plans. There's no fact for the jury as to whether or not, as a matter that they have failed to abide by the contractual documents by fixing those gaps in the facade. There's nothing for the jury to find.
How does the fact that the board took different measures at different times to remediate the defects, the problems, how does that factor into your argument that this can be decided on paper?
One of the major issues with one of the arguments raised by the respondent was, oh, we re-insulated the pipe, but re-insulating the pipe doesn't fix the ventilation problem, which is causing the moisture and mold to accumulate. Re-insulating the pipe doesn't affect the fact that they've done nothing on the facade, which is causing water to seep into the unit. So those type of measures, or taking an investigation into the facade, but not looking at the window gaps where the water is where it's actually seeping in, that's insufficient. There's no issue of fact that they haven't taken action to address the respondents.
Okay, thank you. You have reply time.
May it please the court, my name is Kayla Mann from Gardner & Bloom for respondents. The respondents in this matter have consistently acted within their authority in good faith and in furtherance of the legitimate interests of the 170 East End Avenue condominium. In dealing directly with their appellant's breach of contract claim, the respondents have abided by the bylaws and made every effort to maintain the common elements in the best interest of the condominium, taking the 90-degree pipe first. The respondents have fielded multiple professional proposals and retained outside contractors to address the condensation on the 90-degree.
Well, you know, the bottom line is that you didn't move for summary judgment, right? The plaintiff moved for summary judgment. So even as we can say they proved prima facie, they've established prima facie, they're entitled to summary judgment, what have you done to raise a factual issue in terms of denying that motion?
So the
right to
factual
tell us why you think there are factual issues here, because he's saying, look, if you read this record, Judge, we should win this case. There's no reason to even go to trial. What do you say to that?
So there are numerous factual issues. If we
All you need is one.
Okay, yes. So with respect to the 90-degree pipe, the allegation is that there's condensation on the pipe. This pipe is attached to the HVAC system.
Is that the one that Chubb allegedly took apart?
It is. So it had
and
been
redid it without you guys knowing?
so they left it with nothing on it, and
They left it with nothing on
and
it.
we had to rewrap it. Correct.
Oh, I thought you had to take off what they did and then rewrap
They
it.
just cut the insulation off while they were inspecting the area. Pursuant to the bylaws, the HVAC is the responsibility of the unit owner, and this has been consistently raised by experts and the appellant as the possible source of water infiltration and damage. The complaint itself says that their HVAC installer did not install insulation when it was put in. That installer was...
And also, I think I read somewhere where the plaintiff himself, I mean, the apartment itself is not always occupied. It's frequently, or at least on some occasions, empty, so that may cause, or that's something that the experts pointed to that may be a source of some of the problems that we have here, because there's not a continual flow of air or whatever.
That's correct. So the apartment has been vacant for many years. In addition, as the HVAC unit has not been maintained, it has not been running. So it's not regulating the temperature in the unit. And all the experts have said that this can lead to humidity, mold, etc.
One of the issues here, or at least a perceived issue from your point of view, would be the alleged tortious interference with contract. The concerns of the plaintiff here is that every time he puts in a subtenant, they complain of mold, then they want to bail, so it sort of like breaches the contract. So, and they're seeking summary judgment on that, correct? or they were?
They were.
Well, I didn't see anything on the record that you intentionally interfere with that contract, did you?
Well, I'm happy to go through, there are 7 different claims being made here. Taking tortious interference first, there's no evidence of self-serving, there's only self-serving unsupported statements by the appellant, and there's no evidence of any intentional conduct.
Well, yeah, and my thing about the interference with contract is that you would interfere with the contract so that you could do a deal. You didn't do a deal with the subtenant, right? I mean, that's not what was happening, right?
It doesn't benefit the condominium at all to interfere with these contracts.
Well, no, but and on top of that, you're not interfering it so that you can get something out of that deal, right? Like you
Correct.
had a better apartment for the subtenant.
That is correct. If I can just address the other 2 major issues, the ventilation and the facade, I think it's very clear.
But didn't your own expert agree that there was issues with the facade?
So what there have been 15 inspections in this case. In one instance, our expert took note that there was evidence of a prior facade leak now fixed.
I'm sorry, a prior what?
Facade leak that has now been fixed. And so the condominium is in full compliance with the facade safety inspection programs done every 5 years, most recently in 2022. The report specifically states that it confirmed no evidence of water infiltration through the exterior wall surfaces at any elevation, and that no further repairs were necessary.
The holes that appear in the photographs at record 942, et cetera, those have all been plugged up?
So what you see in those photos, there's no evidence of actual current air or water infiltration.
Were they taken post-remediation, the photographs?
So the appellant at this point is working on remediation. The walls are still open.
Okay, thank you. I'm sorry, did you have?
No, I'm done. Thank you.
Okay, rebuttal.
Thank you, Justices. Just touching on a few brief points that were raised. The photographs that were taken in 2021. There's been nothing done to the facade, to the facade since that time.
Is that as well the photographs of the window frames?
That was all taken in the 2021 inspection of microecologies. It's attached to the Haglid engineering report, which demonstrate those holes, those photographic evidence of the holes, which are still very much in existence. Going through some of the additional things that were raised during respondent's argument, with respect to the fact that the unit has been uninhabitable. This because mold has been reoccurring in it. It's not safe to be habitable. So that's one of the reasons and that's as a result of the fact that the common elements have not been.
Council indicated that the fact that the HVAC unit has not been running may have been a contributing or may be a contributing factor to the mold condition within.
So I do want to, just addressing that as well too, I just wanted to point out that if we
Your
look.
experts address that issue that she raised?
Again, I in fact, actually in the Omega Environmental, and several experts actually go through, including respondents experts, which is Omega Environmental, actually said that the HVAC was regulating the temperature at an adequate rate. And I can provide a record citation if you'd like as well too. Again, the major issue is the lack of ventilation to our unit, which is actually a violation of New York City mechanical code, is causing damage to the unit. And if we look at that issue, that's the undisputed fact that they cannot avoid. The ventilation system is on the roof of the building, and it's something that that cannot be addressed by the respondent, by my client. It is undeniably a common element, and it is undeniably the responsibility of the condo association. So they make these claims regarding the HVAC system, but the undisputed fact, the fact that they can't get around, is the fact that the lack of adequate ventilation to the unit is damaging the unit, is causing moisture and mold to accumulate in the unit, and the experts are in agreement on that. They raised something before, and I think it's just going through one of the claims before, that one of the experts, the FBM...
Yeah, but you know, what they agree on on both sides, the experts, to me, narrows the issues that have to be before the trier of fact. Because there's still, even though you push the fact that there are certain points where the experts agree on, there are many points where the experts do not agree on. So that at that point, you can just parcel out whatever they agree to. Those aren't going to be issues to be tried. And then what remains is what you're going to have to go try. I mean, that's where we're headed. You're not telling me, you're not standing and saying that the experts on both sides agree on everything. That's not the case here, right?
So, and I think that's an absolutely great point that I'd like to address very quickly before I sit down.
You got a minute.
Okay. Again, we're not saying that there's no trial on this, because there's going to be a trial as to the issue of damages. And even if we contributed, that's the Rodriguez case that says we don't bear the double burden.
Yeah, but you only get the damages if you get past liability. So when you're saying that the only trial that we're going to have is damages, you can't get there unless you don't go to, unless you pass through liability, you don't get to go to damages, right? So that's where we're still at. Okay, I got it. We got it. Thank you. Small versus DMJ Group. Okay.
Good afternoon. My name is Daniel Small. I'm the plaintiff appellant.
All right, sir, in reviewing the record here, there is no dispute that there was a conviction here, correct?
That is correct.
Okay. And there's no dispute that the arbitration award that you received for compensation for the years 2012 to 2017 was clawed back, so to speak, as a result of the conviction, and that's why we're here on appeal, correct?
That's not correct.
So fill me in. What is it then?
Sure. I had an arbitration hearing in 2015, and I was awarded damages, and I was awarded a judgment, and that judgment is fully in effect, but it's against a completely different party, has nothing to do with this case.
Okay, but this case,
yes,
there were agreements in place for this case where it did say, unless I'm incorrect, where if you get convicted of fraud, you get nothing.
That's in the IMA, correct?
That's incorrect. That's incorrect.
That's incorrect.
Yes, because the IMA is a separate contract, and I'm not seeking any money under the IMA.
Okay.
That's correct. This is the operating agreement of DMRJ. I'm an owner. I was awarded, or I acquired an ownership interest in 2011, 3 years before any allegations of wrongdoing ever occurred. My performance, I provided services, I received an ownership interest, and I have no ongoing performance requirements under the operating agreement. I'm an owner. And so the idea that,
But does this operating agreement cover the whole, the transactions that are issue or that were arising
absolutely
out
not.
of this
Had nothing to do with that.
Had nothing to do with it.
What I was convicted of had to do with making a material misstatement in connection with a bond consent solicitation regarding bondholders of a portfolio company that had nothing that DMRJ did not own. They did not have any involvement whatsoever. And their counsel in federal court made a statement that that conviction had nothing to do with DMRJ.
Okay. Anything?
Okay. Should I?
Go ahead.
Okay, sorry. So
You left us speechless. Go ahead.
I'm sorry. So, well, but that's 100% true. Actually the findings in my conviction is that I had no intent to deprive anybody of money or property, and that my intent was to pay everybody back.
So let's
those,
go to the
those were bondholders,
counsel.
not DMRJ.
Let's go to the disclosure issue here. You took the fifth. You took the fifth repeatedly. You said you weren't going to take the fifth at deposition, but you did. And your adversary, the other side, the other parties say that the information that they saw at deposition was material. It is relevant to their ability to craft a defense. How do you justify, or how do you explain, not even how do you explain your actions? Didn't the court have the authority to dismiss your case under those circumstances?
Absolutely not, and I'll explain why. One, I never said I would not take the fifth, ever. Two, what I took the fifth of, I've always believed had nothing to do with my case here. 3,
But the issue here is whether the information that was sought, whether the query that they made concerned matter that was material and necessary in the preparation of their defense. That's like CPLR 3101. Was that information material and necessary?
they waived their right to that information. They never made an application to the court saying that this is important information to them.
You're
During
saying
the
that
court-
they had to do a motion to compel as opposed to doing a motion to dismiss?
They didn't do a motion to dismiss.
No, I'm asking you, are you saying that?
Yes, because I believe that that information was not relevant to their defenses or my case.
Well, to correct the point, discovery in this state court is not based on relevance. It's whatever is necessary and material. So relevance comes later on, once you disclose everything, then there's a whole argument of whether or not that should be admitted or not. What's discoverable is not necessarily
but-
admissible. Well, you gotta let me finish.
I'm
You
sorry.
might like what I have to say. What is discoverable is not necessarily admissible, as they say, right?
Understood. But the question here is, should I have been sanctioned and have my case dismissed for asserting the Fifth when I complied with every discovery deadline and there was never an order telling me which questions I had to answer or I didn't have to answer? So, and then the discovery was complete. They filed, I filed a note of issue, and they waived, under this court's ruling in Jenkins, it says that they've waived their right. It's only information that's necessary that needs to be disclosed.
Thank
If they've waived their right to that
Got it.
information.
Thank you. You have rebuttal time. Thank you.
Good afternoon. Warren Gluck on behalf of Holland and Knight for DMRJ, the respondent here. What's missing from Mr. Small's argument is a critical fact. The DMRJ operating agreement provides that it is the lesser of DMRJ's profits or Mr. Small's gross profits under the investment managing agreement that's payable. So right there in the DMRJ operating agreement, it is not only the IMA incorporated by reference and defined, the mechanism for the bonus payment is the lesser of the DMRJ profits or Mr. Small's
And
profits.
there were no profits.
No profits
Went to
whatsoever.
bankruptcy, right?
Bankruptcy, the Black Elk was both the largest asset at PPVA, but also the largest asset in Mr. Small's portfolio. The losses associated with Mr. Small's Black Elk position with a loss carry forward that is undisputed wipe out any possibility of profits here.
So even if he's entitled to, even under the operating agreement, he's entitled to get it, there's nothing there to give him.
There's nothing. And the notion that these questions on Black Elk were irrelevant doesn't make sense. That was the biggest asset in the portfolio.
Well, you're getting to the point, I'm sorry.
Oh, I'm sorry. So there is linkage between what was before the arbitrators and what happened now after conviction.
Sure. Now, the arbitration occurred before the fraud emerged.
That was the point I made. Okay, go on.
It absolutely occurred before the fraud emerged. And then, years later, Mr. Small brings suit against DMRJ only and not PPVA because it was in bankruptcy, asserting his right to profits under the DMRJ operating agreement. But that operating, this is Appendix 143, 149, 151, explicitly makes the bonus the lesser of his IMA profits,
Which is not, which you can't get if you're convicted.
which is a zero, and you can't get if you're convicted. By both, either and both, by the way. And the or the profits of the DMRJ. Now, here's the really critical point. The reason Mr. Small started suing DMRJ, he opens up in federal court seeking an injunction to prevent PPVA's bankruptcy from operating. That was the express purpose. You forgot about subject matter jurisdiction, it gets remanded to state court.
State court.
2 attempts at an attachment to tie up all of PPVA's operating capital. It's public knowledge how much litigation and work has gone into this. This is the purpose. We say, hey, Mr. Small, it's pretty obvious under this agreement that the Black Elk issue is going to be highly relevant because that was the biggest part of your portfolio and the losses make any kind of bonus impossible. We say, how about we stay the action pending the conclusion of the criminal matter, but he doesn't want to do so because he wants to tie up PPVA's assets. He was provided the
So
opportunity.
that leads into the whole taking the fifth in this case here. He maintained during deposition that certain portions of questions were taking the fifth, and his argument now is like, there was never a motion to compel. I could have answered, did he raise this in Supreme Court saying, look, I would have answered these questions if there were a motion to compel, which I'm not so sure if there was an affirmation or an affidavit to that effect, right?
There was no argument to the trial court. He took the fifth 60 times in relation to the most material issue in the case. And then let's remember, the only summary judgment motion we file is, of course, Fifth Amendment. It's being used as a sword. We can't get necessary information. And at no point within the lower court, when, by the way, he had counsel, did he say, oh, well, I'll testify. I'll take the deposition.
In response to the motion.
In response to the motion, either in response to the motion or at oral argument. There was then 6 months between the oral argument and the decision or something. And the law doesn't require it. Most importantly, he hasn't rebutted any of the cases in our brief, which says that this is roundly within the discretion of the trial court. The trial court also teed this up when we had our motion to stay.
It has inherent authority to provide the remedy that you received.
That's correct.
There is no requirement of a 3126 motion.
There's no requirement. And this is the point, is that not only did he decline to have this matter stayed so that he could answer the question, we haven't even heard today that he's going to waive his fifth. Sentencing hasn't occurred yet. I'm sure there will be appeals. There have been many appeals. So even the notion that Mr. Small is going to answer these questions would be odd.
There's too much ambiguity out there for him to do otherwise. That's what you're saying.
That it's totality.
Anything he says here is going to be deemed an admission.
Absolutely, and it's totality. It wipes out the bonus. By the way, we've also had a jury trial where a director who was found liable for not screaming to the world that this had crystallized at a zero. It was before Judge Rakoff. A final, just for 30 seconds on our
30 seconds.
The defense of his motion. He made a motion for summary judgment. There are 10 independent issues of fact the court identified, including the value of black elk, including the losses associated with black elk, including the value of this Monsanto note, which, by the way, was part of the black elk fraud. And on each and every one of those items, Judge Justice Cohen says, oh no, issue of fact, motion denied, properly denied. But the more important one is this Fifth Amendment where he was provided every opportunity to stay the case.
Counsel, I want to ask you a last question. Was there a connection between the conviction and what we're doing here today?
The only connection with the conviction is it would forfeit the bonus under the IMA, but also the conviction relates to defrauding bondholders of black elk. The reason bondholders is important, PPVA's primary holding and Mr. Small's primary holding was the equity. If bondholders were harmed an ounce, the equity was zero and always zero. You don't even get to harm to the bondholders unless it's a zero.
And you can't find out because he took the fifth. I mean, you couldn't even do any exploration.
And we couldn't even ask the questions on the topic.
Got it. Thank you.
If I may, I guess one is this idea that there were no profits, Your Honor, is just not correct, or that I have to forfeit profits under the IMA. The losses that he have alleged have to do with the stated carrying value of these assets. I wasn't charged with that crime, but that crime was charged by other members of Platinum, and they were all acquitted of any alleged overvaluation. But the alleged valuation of the three assets that they named, Black Elk, Desert Hawk, and China Cablecom, are realized-only assets. I'm not seeking any money from those assets. Those assets are on a realized-only basis, and it's only when they're sold based on the purchase and sale prices.
Well, Supreme Court, okay, let me get back to the basic. Supreme Court here granted the defendant's summary judgment motion on the grounds, at least when I'm reading the decision, Supreme Court's decision, based on your taking a fifth on a lot, okay? And the question becomes is that, what did you put before Supreme Court in opposition to that motion saying, hey, Judge, I'm waiving my fifth. I'm going to testify to everything. Did you say that in your opposition to that motion for summary judgment, saying I'm entitled to get this complaint dismissed because he took the fifth?
Well, I think
the answer is a yes or no.
At the time, it was never, I was never asked to do that.
What, you know,
I was never asked to waive the fifth.
what,
I
who,
wasn't, Your Honor.
when you say you were never asked, were you represented by counsel?
I was.
You talked to your counsel about that, right?
My
I mean, you're not
counsel-
going to ask the court to help you, right?
No, but my counsel basically
We put
said,
that meter away a long time ago, you know, I mean.
my counsel said there's, if you look at this court's decision under Brown versus 303 West 42nd Realty Corp., it needs to be a violation of a court order telling me which questions I have to answer.
Oh, you don't understand. The question is, it's a motion for summary judgment. You got to raise a factual issue. When they're saying that you took the fifth, and that would prevent them from doing the discovery that they need to get to their case and
But they
defend.
waived that information. Don't they have to actually, I mean, they put a letter in saying all discovery is complete. Then they filed this other motion.
Counsel,
How can they do that?
counsel, originally you stated I could have been sanctioned, they could have moved for a motion to compel. When they filed the motion for summary judgment, could you have said, Judge, I will submit to questioning, I won't plead the fifth? Could you have settled that motion that way?
Absolutely, ma'am.
Thank you.
But just one question. I took the view, it was my position in good faith that those questions were not related.
See, that's the thing. You can't do that in state court
But doesn't the
discovery.
court have to order me to say, no, you're wrong, Mr. Small, either answered or waived? They can just throw it out without even giving me that option, without putting me on notice?
I'm not here to answer your question.
I think, isn't that the law, that they actually have to, I have to violate an order? Isn't that what it says in Slights versus Wettinson? That you, in order to be, the drastic sanction of discovery, I thought this court believes that heavily favors cases being tried on the merits.
We got your argument. Thank you very much.
Thank you for your time.
Thank you. Thank you, Mr. Small. All right, next case up, Camelot versus Morgan Stanley.
Good afternoon. May it please the court, Scott Musoff from Skadden Arps for defendant appellants Morgan Stanley and Goldman Sachs. The plain letter and spirit of the Private Securities Litigation Reform Act, the PSLRA, dictates that a stay of discovery should remain in place while the defendant's motions to dismiss remain pending before this court.
But what do you have, before this court or before the Supreme Court?
Well, Your Honor, I'll get to
When I say Supreme Court, I mean the trial court. not the
trial
US
court.
Right.
Your Honor, we believe that it has to stay in place. First of all, we believe it applies in state court by its plain terms. And then we also believe.
Let's assume it does apply. Let's assume the PSLRA is here. Let's get right to the heart of it, whether or not you're entitled to the stay of discovery or not.
Right. So if the PSLRA applies in state court, which it does because it applies to any private action.
Right. That's subsection B, I think, right?
Exactly, Justice Owing. So then the question is, back to plain language, the second term, pending. What does the word pending mean? The word pending means under consideration. And the motions to dismiss.
Counsel, wouldn't it have been much clearer if they'd said pending or on appeal? They didn't say or on appeal. They just said pending.
Yeah, Justice Moulton, there's lots of things in the PSLRA that they could have done more clearly, but I would say they didn't use the words denied. They didn't use the word decided. They used the word pending, and they've used the word pending, Congress, in a number of states. For example, we cite the Clayton Act, where a pending action, pending includes appeals. Plaintiffs say, well, that's action, not motion. But what those cases discuss, those cases about the word pending are using it as an adjective, whether it's a pending action, a pending cause, or a pending motion.
But isn't the subject of the adjective important? I mean, most of your cases do say action or suits or cases, the statutes that you, and the cases that you offer in support of this argument. But isn't the context important? It's a motion.
Justice Moulton, for example, in the Powers case, on a motion for reconsideration, the federal district court said, no, that means the motion is still pending.
So, counsel, I'm looking at in Ray Solomon Analyst litigation. It's a Southern District case from 2005, and it said the purpose of the statutory stay in the PSLRA is to prevent abusive the abuse of discovery in frivolous suits by postponing discovery until after the court has sustained the legal sufficiency of the complaint. Once that legal sufficiency is sustained, the purpose of the PSLRA has been served. So what you're arguing here is that the denial or that the disposition of the motion to dismiss has to do with the appeal process as opposed to the decision of the motion court. You're asking for an expansion, aren't you?
Not exactly, Justice Gonzalez. What we're arguing is that the motion to dismiss, in large part, due to the unique structure of the New York court system, where the appellate division is a branch of the Supreme Court.
Here's what, I hear what you're saying, but here's something this is a congressional statute, this is a federal statute, right? The guys in Congress wrote the statute. So they had in mind the federal courts. How does the fact that there's no interlocutory appeal in federal court affect your analysis here, affect your argument? Because, in the federal court, you get a denial of motion to dismiss, that's it. You're going all the way to trial until the case ends, and then you take it up to Second Circuit. Here we have interlocutory appeals, which Congress, when they're writing this, they're not thinking about state courts. They're just thinking about federal courts. So how does the fact that there are no interlocutory appeals in federal court affect that argument? Because by accepting your argument, saying that an appeal to state court means that there's still a pendency of the motion to dismiss, that would be, in a sense, encouraging forum shopping, wouldn't it?
Justice Owing, and
Follow that?
I do follow it, and I think it's a corollary to Justice Gonzalez's question, which is a couple of points. Congress doesn't have to contemplate every type of state, every type of system, and in fact, we see that in the cases we cited where it uses the word motion to dismiss, but the California cases say we call it a demur, but it's still going to apply. So in the safe harbor provision, they say summary judgment, some states don't. You have to look at the plain language of the word pending. And I'll also note the few federal interlocutory appeals that were granted, while they don't explicitly rely on the PSLRA stay, in the pure securities motion to dismiss case, we cited a number of them where the stay was granted. Plaintiffs cite class cert and other decisions. So I think there is some harmonization there. But I want to come back to—
Well, those are rare instances of
they are rare.
Very rare.
But what happened is after Cyan and the Supreme Court reaffirmed that the state courts are capable and more than capable in our commercial division of handling 33 Act cases, that you have to apply the plain terms of the PSLRA. And I just want to leave with one very important case. The First Department case in In Re Association Bar of New York, where this court held that it's thoroughly well established that the appellate division is a branch of the Supreme Court that is in effect the Supreme Court sitting en banc. The reason that language is very important, and I invite you to ask my friend, and I mean it literally, my friend.
Yeah, you're saying it was still one unit.
One unit, because ask if the Second Circuit granted an en banc appeal after a decision, would anybody seriously say that appeal is not pending anymore? You would never say that. And that's what's happening here. We're entitled to get this court's view on the sufficiency of the complaint. This court is empowered with original jurisdiction. It doesn't even give discretion sometimes after trials to the trial court. This court is empowered with determining, does the complaint, to Justice Gonzalez's question, meet the legal sufficiency? And until this court decides that, our motions are still pending. And they're going to say, well, that takes a long time. I've sat in district courts around this country that have sat on motions to dismiss and lead plaintiff motions for years. Congress was well aware of that. They made exceptions to the PSLRA stay that don't apply here. And what they decided in their legislative decision is that it's more important to stay discovery until the court determines the legal sufficiency, as Justice Gonzalez points out. And that's up to the 5 justices that will hear those motions in December.
Okay, thank you.
Thank you.
May it please the court, Jonathan Youngwood, Simpson, Thatcher, and Bartlett. I represent 14 underwriters that are not Morgan Stanley and not Goldman Sachs. They include JP Morgan, Citi, and 12 others. But I do want to say that we join in the arguments that Mr. Musoff raised. But I rise to raise a separate argument, which is separately briefed, which is to request a discretionary stay under CPLR 2201, which the trial court denied. My 14 clients are in a different situation than Morgan Stanley and Goldman Sachs as pled under the complaint. And the difference is that while the case in general revolves around alleged undisclosed conflicts of interest between certain underwriters in Viacom CBS's 2021 secondary offering.
Youngwood, don't you need to make this, and actually didn't you already make this application in the straight appeal?
We made this application to the trial court. We made a shortened application to this court. We lost both times, just as I believe my colleagues
That
at
begs the
Goldman.
question, is this an end run around that ruling on the motion?
It's an appeal of that ruling, I would say, Your Honor. We sought the immediate relief to stop.
I mean an end run around the panel of this court that denied your motion.
I don't see it, obviously, as that way, Your Honor, or we would not have pursued it. We sought that attempt to get an immediate stay so that we did not have to go through document discovery. We have now gone through document discovery. We come to you hopefully 2 months before we are before you on the merits of this. And what's between us and that argument and a decision are depositions, which are the most obviously onerous and burdensome aspect of discovery. We think that the arguments...
we have, if I recall my days in the commercial division, I recall that there's a rule for discovery is, there's no stay in discovery. You were going full speed ahead. Did they change that rule? Am I incorrect?
Your Honor, before Justice Barak, he would have the discretion, obviously, to stay it, and we think this court, sitting in review of that, has the discretion to stay it. We think that the arguments that we have of our clients are clearly novel and of first impression. That's not just my opinion, it's actually Justice Barak's at the argument back earlier this year. And it is both the issues that Morgan Stanley and Goldman Sachs will raise before this court in December and that we will raise are very significant cutting-edge issues that we think warrants a pause in the case so that my clients don't suffer the...
The issue here, counsel, is sufficiency, right? The sufficiency of the complaint. On a motion to dismiss, it's not a motion for summary judgment. You're raising concerns with respect to the merit of your case, but that's not before us, is it?
No, Your Honor. I'm asking that you issue an order that prevents depositions until you have time to consider that decision.
As to whether the complaint is sufficient.
Yes, and both under the PSLRA stay and as Mr. Musoff said, there are many examples, yes, it's rare, many examples where there is an interlocutory appeal, and when that interlocutory appeal is heard, almost every time discovery is stayed. Here we're going to have that appeal, and I don't mean to make...
Yeah, but when you have an en banc, when you have the Second Circuit, the entire court en banc, granting the interlocutory appeal, I'm pretty certain they're going to issue a stay on their own, right? They're not. You don't need the PSLRA to help you out. I mean, the full court's weighing in on that issue. That's a big deal.
Yes, Your Honor. Again, Mr. Musoff will get up and correct me if I'm wrong. I think his point was the appeal still pending when you go to en banc? The examples that we...
Yeah, I know the appeal is pending, but they grant you to stay, right? The Second Circuit is going to give you to stay.
But Your Honor, I think they grant the stays in these cases, even if a simple panel of the Second or Third or 10th Circuit are going to hear it. It doesn't require an en banc to grant the stay. The Barada case, the Tennessee Council case, the Williams case, and others in our briefs, I think all stand for that proposition. Okay. I see my time has expired.
Thank you.
Good afternoon. May it please the court. John Rizzio Hamilton from Bernstein Litowitz for the plaintiff's respondents. Let me get right to the heart of the matter. The PSLRA stay, even if it applies in state courts, has been fully satisfied here and terminated when Justice Barak denied the motions to dismiss, in part. There are many reasons
Yeah,
why.
but what do you think about his argument saying, the Supreme Court, the Appellate Division, in the Constitution, we're one unit. We're the Appellate Division of the Supreme Court. So in a sense, even though there's a denial downtown, it's still a pending motion to dismiss because we have the ultimate say as to whether or not that's going to go up or down.
So I would, two big picture points in response to that, and then I want to circle back around to some others. First, it defies logic. I understand the court structure, but regardless of whether this court is technically part of the Supreme Court, that does not resurrect the motion. In all events, the fact remains that the motion has been fully considered and denied. It is therefore no longer pending. Sometimes law, the practice of law,
It's only an appeal that's pending.
it's only an appeal
Not
that's
the
pending
motion
at that
that's
point.
pending.
And I would go so far as to say, Justice Owing, that an appeal to this court cannot even be taken if the motion is still pending. Under CPLR 5701A2, the motion must have been decided in order for this court to have appellate jurisdiction. Thus, if the motion is still pending, as my friend Mr. Musoff contends, I respectfully submit that this court would not have jurisdiction to consider the merits appeal.
Yeah, you're here for nothing.
And we're here for nothing, right. Now,
I
sometimes
don't
law...
think your clients want to hear that, but okay.
Yeah, no. Well, sometimes law is exotic and full of shades of gray, and sometimes it's
Oh,
really
no,
simple.
we never think it's exotic.
When a motion to dismiss has been decided, it is no longer pending, and it is that simple.
Well, I mean, this goes back to the early point, as my colleague Justice Moulton says. I mean, Congress could have just said pendency of any action. Why did they have to slice it to just say motion to dismiss, right? Yeah, if you say pendency of any action,
Right.
then you'd be out of luck at that.
Yeah. I would have a problem if it was pendency of any action, but it's pendency of any motion to dismiss. So that circles me back around to the point I wanted to make at the outset, which is the argument just contradicts the statutory language, right? It says the stay expires when the motion to dismiss is no longer pending, which has occurred here back in February when it was decided.
I mean, the bottom line is there any ambiguity in that statute that requires us to just start,
No.
interpreting it, right?
None. Directly answer your question, none whatsoever. As a matter of fact, the request they're making is completely unprecedented. No court in history, either at the state or federal level, has ever imposed a PSLRA stay while a motion to dismiss was on appeal. No court in history, okay? Even the judges and the justices of the Supreme Court who believe that the PSLRA stay applies in state court, such as Justice Barak, all agree that it terminates once they decide the motion to dismiss. And in fact, as you pointed out...
Yeah, because and let's go back to my point, is if we were to disagree with you, you start having this sort of forum shopping situation going on, right? I mean, then people will not run the federal court, they'd run the state court then, or they try to get a case removed from federal court to state court because they know, you know what, if we got an appeal, we can get the stay.
Exactly. And it absolutely contradicts the purpose of the stay to say that it remains in effect during the pendency of an appeal after the motion to dismiss has been denied. The purpose of the stay is to eliminate frivolous litigation, right? And to eliminate costs that are imposed on defendants by frivolous litigation. But once the complaint has been tested by an able trial court, which it has here, that purpose has been fully served. And I just want to circle back to your question about federal practice, Justice Owing. On appeals, interlocutory appeals in federal court are indeed rare, but they are possible under Section 1292B. There's a demanding standard for it. But even when a trial judge holds that that standard has been met, they do not ever, never impose a stay during the pendency of an interlocutory appeal under the PSLRA. Sometimes they impose a stay, and sometimes they don't. But when they do, they absolutely do not do it under the PSLRA. They do it under their discretionary authority because they know full well the PSLRA stay does not apply once an appeal is taken from a motion to dismiss order. And in fact, Congress, when it wrote the PSLRA, was fully aware that Section 1292B provided an interlocutory appeal mechanism. And if Congress had wanted the stay to apply during those rare instances when that interlocutory appeal is granted, they would have put the word appeal into the statute.
That's exactly what happened here. The appellants here moved before us for a stay, which was denied.
That's right.
The discretionary stay that you're saying that, you know what, in federal courts, yeah, they're going to grant the interlocutory appeal. They don't do the PSLRA. Right. They do it under the discretion.
That's exactly how they do it in federal court, and Congress
That's
was
how they
well
do the
aware of
end
that.
run, as my Justice Moulton would say.
Right. And that's what they're trying to end run here.
Thank you.
Thank you very much.
So, counsel, your adversary has said something most intriguing. He says that your application is novel, that no court anywhere in any state has ever granted a stay of discovery along the grounds that you are arguing today.
Justice Gonzalez, we started our brief with this is a novel issue because of the novel structure of the New York State courts and how rare you have in courts that don't allow permissive interlocutory appeals to another branch of the same court, how rare those appeals are. There are no cases that say, appellate courts that say it does not apply when you're doing that. It is novel. We agree with that.
I think the
And this-
point was whether or not there's been a federal court that has issued a PSLRA stay while granting an application.
Some of the
with having
courts have
interlocutory-
noted the purpose of the statute, but there is a distinction between the federal courts and this court because they're not branches of the same court. And what we're asking to do is faithfully apply the plain language of the statute.
But that goes
Congress
to the point.
didn't
No, but
think of
counsel, but
this.
that goes to the point exactly what I said. If no federal court has done that and they've only exercised their discretionary stay, why is it now that we should agree with you and give you a PSLRA stay when no other court or no other federal court has done that? And instead, we've already denied your application for a discretionary stay.
Because federal courts have applied the PSLRA stay when you've made motions for reconsideration, the Powers case. They've done it
But that's below. Motion for reconsideration is below before. the
My
trial
point
court.
is, it's not limited to the specific motion pending. That's a continuation of it because very similar to here, it's before the same court. A final decision hasn't been made yet. It doesn't say decided, it says pending. In Ray Solomon, as Justice Gonzalez points out, Judge Lynch says, my concern is successive motions to dismiss might prolong this forever. That's a concern he has, which you don't have here because there's going to be one interlocutory appeal. But he granted the stay there.
But you're saying that we are part of the Supreme Court, and when there's a motion such as yours, a motion for a stay of discovery pending an appeal, we are required to issue the stay.
Yes, that Congress's statute, the federal law governs, and you have to apply it by its plain terms, even if the results may at times not be logical, whether you agree with the legislative intent behind it. But you have to look at it. They didn't pick the word decided. They didn't pick the word denied. And we see it in multiple cases, including in Ray Solomon, Justice Gonzalez. Judge Lynch granted the PSLRA stay there on successive motions to dismiss, which is more analogous to this than even an interlocutory appeal under 1292. In terms of forum shopping, it's the plaintiff that chooses the forum, Justice Lang.
Yeah, but you can
The
also
defendants aren't going to run there. And if anything, the interlocutory appeal system itself is beneficial to both sides that you unfortunately don't have in the federal.
Right, but the forum shop, I mean, you guys can always, the other side can always seek to remove if it's in federal court or state court. I mean, there's always that.
There's always that. But the
Always
forum, defendants can't forum shop based on its plaintiffs that chose the forum.
Okay, thank you.
Thank you. Thank you.
Very good, thank you. NYC RCA affiliates versus James.
May it please the court, Lauren O'Brien on behalf of the City of New York. The joint bidding statute authorized JB 4.0.
You know, I thought Supreme Court wrote a pretty good decision. I mean, the way he says it is that Supreme Court, and this is based on what was in the record, is that, you know, if you tie the two together, the public works portion as well as the interference utility interference work together, the argument is that the public works portion is going to be increased because that fixed amount is so low. There's no way that I'm going to be able to, you know, make a living on this contract. That's a pretty good argument, right?
So the problem with that argument, there are several problems with that argument. The first is that there's no real legal source that was relied on. The one that the Supreme Court relied on was GML 103 as it was applied in Diamond Asphalt. But the problem with that is that that law has been superseded now by the joint bidding
Let's assume
statute.
that the joint bidding, the Senate version of the bill or whatever it is, that's the law. Let's just say that applies to joint bidding process. The argument then is that, you know, oh, you're saying that the whole argument of the 103 public fisc doesn't even come into the picture. Is that what you're saying or no?
I'm saying that the Supreme Court's, the ground that the Supreme Court relied upon to find the joint bidding provisions unlawful no longer applies. And also, if you focus more on these more factual assertions or arguments made by the petitioner that they've kind of manipulated their bids for the public portion of the work now because of this system. That is really based on this fallacy, this false premise that the bids need to look the same under the city's joint bidding scheme as it did under prior bidding schemes. And that's just incorrect. In fact, if you look at the history of the joint bidding statute, lawmakers understood that under past systems, there were issues with inflated prices for the utility interference work, which is work that's supposed to be a small portion of the work of the overall project.
So that was a decision on the legislature part because the utility work was such a small portion, it was the tail wagging the dog. It held up the whole project.
Correct.
Because obviously, if the city's coming in and negotiating, they're at an upper hand versus the utility company coming in and trying to negotiate that portion of that project.
That's right, Your Honor. And the lawmakers specifically pointed out the utility, the city's contractor here, was essentially in a de facto monopoly position, and they were able to just hold up the entire project, often, delaying the city's public work projects for many years, important projects for the city, and also causing street closures, traffic issues for pedestrians, issues for local businesses, and things like that. Those are all things that the legislature considered when it decided to pass the joint bidding statute authorizing the city
Counsel, when you look at the precedent by way of legislation that came before this, it seems that the city has been trying to curb waste and curb corruption as well, and that what we have before us has gone through a whole number of prior iterations. So with respect to the Article 78, it would seem that the reasonableness standard, one could argue, is satisfied. But here the contractors are saying this is an unrealistic scenario. The scheme doesn't work. You're causing us to put in bids that are totally skewed. What do you say to that part of it?
I would say that it's incumbent upon them to point to a law that is being violated with this scheme, and they have pointed to no law that hasn't been superseded by the joint bidding statute. And it's also just, it's their assertion that they're manipulating their bids or that the utility interference prices now are too low. Again, that's sort of comparing to prior prices, at least, as the legislature accepted, that's in comparison to these old utility interference prices, that those were the prices that were actually too high. And so there's this recognition that, the prices are going to change under this new system. And the other point I wanted to make is that, the basis for their original petition was GML 103 and Diamond Asphalt, and they've really abandoned the basis for that petition, and we think that this case can end there.
Great, thank you.
Very much.
If it pleases the court, Scott Simon, Getz Fitzpatrick, counsel for the respondents. I'd like to make 3 points, and all these points really come down to...
let me ask you this question. Let's assume that GML does apply, 103 does apply, right? Because that's your basically the argument, right? If you don't have 103, you're not going to have a case, right?
That's what counsel says.
So let me ask you, if you're arguing about the fixed costs of the utility interruption work, isn't there an easier way to challenge that, like for an Article 78? Why do you need to go through this whole thing about just literally tossing out a joint bidding process that's arguably authorized by statute?
If I may, Justice Owing, let me first answer the question about whether General Municipal Law 103 was superseded by the joint bidding law, because I think that's the key issue here. And the city contends that the Supreme Court applied outdated principles, right? That the 2014 joint bidding statute superseded GML 103. But in Diamond Asphalt, the Court of Appeals held that in order to override General Municipal Law 103, you need, quote, an express or definitive declaration.
And counsel, that's what happened. I think. Tell me why it didn't happen with the 2014 statute.
Justice Moulton, the answer is that the bedrock principle that a municipality has to obtain the lowest responsible bid for public work, the
Is
joint
that
bidding.
the only principle? I mean, I disagree with that premise. I don't think it's the only principle that the city has to go under. They're also going about the old system caused a great deal of inconvenience to parties. Can the city consider that?
The answer is this court in Tormenta, as well as the Court of Appeals in Diamond Asphalt, held that while other considerations are possible, such as efficiency or price, or negotiation, how long it takes to get to a contract, the primary goal, Justice Moulton, is the price. And
then they passed the joint bidding statute. The legislature did.
And all the joint bidding statute says is, as does General Municipal Law 103, that the city, quote, shall award the contract to the lowest responsible bidder. Lowest responsible bidder has always been defined as lowest responsible bidder for the city's public work. Now,
So even if you apply 103, 103 would not be violated as long as you get the bid that's the lowest responsible bidder, right? I mean, that's basically what they're trying to safeguard the public fisc. 103 is trying to safeguard the public fisc, right?
And Justice Owen, you're right, but the problem with that is how could you have a lowest responsible bid for the city public work when, as you pointed out earlier, there's an impossibility.
So that's why I go to, why don't you do an Article 78 to challenge the utility interference work, saying that you guys are kidding me. That dollar figure that you're putting out as a cost for this work is, first of all, it's arbitrary and capricious, and B, it's totally irrational.
Because the answer to that question is the JB 4.0 utility price list is by itself unlawful. You cannot have a price list that is so low.
Well, it's only unlawful if we believe that the statute that we're talking about here, the joint bidding statute, is not going to override 103. If the joint bidding statute is there and has overridden 103, then you're still back to where I'm saying, right?
But the Court of Appeals has held that the primary public policy is that municipal bidding cannot be manipulated by private, investor-owned.
That's all before the joint bidding statute got put in place, right?
But the joint
Because it says, as my colleague was mentioning, it says notwithstanding any general, special, local laws or rule or regulations to the contrary, the city of New York may include blah, blah, blah. I mean, that's pretty clear to me, saying, whatever else is out there, this is going to take precedent.
But Justice Owing, lowest responsible bidder, which is in the 2014 joint bidding statute, you can't have a lowest responsible bid.
I'm glad you mentioned that. So let me ask you this question. Where was it exactly that your papers are saying that I have to manipulate the numbers so that my public works numbers are higher because the interference work is so low? Where was that exactly procedurally?
That was in the initial petition, Your Honor. We submitted affidavits from contractors. We submitted
On reply, or was that
on the initial
original
petition. And those contractors said, and I quote, right, I inflated the city's portion of the public work.
Did they attach documentary evidence to that statement?
Absolutely, Your Honor. They said that I could not bid a fair price for the city's public work because the joint bidding price list was so low. But let's even go to
Counsel, weren't a number of your clients actually awarded the lowest bid?
I'm sorry, could you?
Weren't a number of your clients actually awarded the lowest bid on certain projects?
Indeed.
And that seems to be contrary to the principle that you argue in your brief, that this whole price list, the JB 4.0 price list, is so low that it prevents you from being able to bid on these contracts. Didn't you say that?
There were different contractors. Some of them said they believed that they couldn't inflate the city price, and so they didn't bid at all. But the contractor who actually won said, I bid more for the city's public work than I would have if that price list hadn't been here. But before I said, please, let me address one point that counsel made. This idea that it is the contractors who were monopolists in the process of bidding before that joint bidding statute came around. DDC's commissioner gave a letter to the city agencies, the city council, excuse me, on May 23rd, 2023. That's linked on page 5 of respondent's brief. The DDC commissioner cited the private utility companies' inaction, causing costly project delays and extra costs, not contractors negotiating with the private utilities to reach a fair price. Think about what's happened since that February 2022 price list was promulgated. We've had some of the highest inflation in the history of this country, 10% or more, and that's not even including the higher labor costs or the higher material costs that these contractors are experiencing. That price list hasn't changed. Where does that cost go? It can't go to the utility side. It has to go to the city side. The city taxpayers, the public fisc, is being harmed by this process. And the public policy of the state of New York is that notwithstanding any cost of efficiency, speed, having the streets open, whatever the city is saying here, the key is that the taxpayer has to be protected, and JB 4.0 does not do that.
Thank you.
Thank you.
I just want to close by saying that JB 4.0 was developed by the city under the joint bidding statute as a reasonable way to deal with
all
this.
those arguments that were raised by your adversary here, these are all positions that were fully fleshed out, put before the legislative bodies in terms of the pros and cons of doing this joint bidding and in terms of this JB, promulgation of this regulation. I mean, it was all there. I mean, that's something that's what the legislature does, right? I mean, they look at all the views and they figure it out, and this is what we're going to come up with. Somebody's going to not be happy, and some other people are going to be happy, and
That's right, Your Honor. It was before the legislature, and it was also before the legislature the fact that this has been an issue that the city has been dealing with since decades ago. Diamond Asphalt was a decision from 1998.
I mean, the legislature in enacting the joint bidding statute clearly was I wouldn't say repudiation, but wanted to reverse the Court of Appeals decisions about saying you can't do that. You can't do joint bidding.
Correct, and that's sort of replete in the legislative history of the statute. And the final thing I'll say is that the city's approach appears to be working. It's fostered robust competition for these contracts, including by contractors not involved in this litigation.
What do you say about the argument about how, the utility interference work expense or cost is so low about, someone can challenge that. I mean, it's not like you can't challenge that, right? Instead of trying to throw out the entire regulation, you can do a specific challenge, a challenge to a specific project saying, that number you got is totally irrational.
That's right, Your Honor. Just like any other agency action, these provisions are subject to Article 78 review and arbitrary and capricious review.
Instead of throwing out the bathwater, you might want to take a look at everything else beforehand, right?
Right. But that's just not what was brought here. And there's really no dispute about that. And again, the bids have been falling below the city's estimates for what these projects should cost. And at least one project that was challenged in the underlying proceeding.
You made it, that triggers something. With respect to the utility work, if there are cost overruns, there is a process where that they can put in an application and say, look, the money here, I can't make it.
That's correct. And that's sort of a direct response to the argument they make in their brief that there aren't, safeguards within this joint bidding system.
Because in that situation, the utility company can say, no, we'll take care of it. We're not going to pay you, or the other ways, well, okay, here, this is where we're going to, that's a negotiation then.
Correct, yes. And it's set out explicitly in the provisions that if there's extra work that the contractors and the utilities will negotiate that directly. And the city won't be involved in that.
Okay.
So unless Your Honors have any further questions, we would ask this court to reverse and deny the.
Thank you.
Thank you.
Mato versus Franklin Plaza Apartments.
Good afternoon, Your Honor. Nicholas Timko, Gordon, Timko, and Rodriguez for the plaintiff appellant Mato. May it please the court, we ask that the court reverse the decision of the lower court, which granted summary judgment to the defendants in this case. This is a case where plaintiff exited an apartment, walked down the steps, slipped and fell on urine as he was going outside at 1:30 in the morning. The central issues in the case are, did the defendants make a prima facie showing for summary judgment based on the fact that there was a recurring urine condition, and did the plaintiff raise a question of fact? And so a couple of things.
What do you base your statement that there was a recurring urine condition? You mean the statement of the plaintiff's girlfriend?
Well, the
If
plaintiff's
I'm
girlfriend
correct,
specifically used the
counsel,
word.
allow me, please.
I'm sorry, Your Honor.
Let Justice finish.
No, allow me to finish.
Oh, I'm sorry.
He gets to ask the question first.
Yes. I was struck by the kinds of records that are kept by the defendant here, and there's logs, and there's maintenance schedules, and there's protocols set up for maintenance. I didn't see anything about complaints that were given.
Okay, so here's the evidence that there's an ongoing condition. One, the plaintiff's girlfriend used the word ongoing. Two, Mr. Alpert, which they based their whole motion on, was the property manager assigned 2 years after this. So he testified, and I can give you the page numbers, he had no personal knowledge of what the protocols were at the time of the incident. He testified to what the standard of care is for good and accepted building maintenance, as he understands it, which is what he laid out. He testified once, and then the porters testified and said they saw signs on the stairway that said, no urinating in the stairway. The lower court interpreted that as a warning to people walking down the stairs to look for warning, but it certainly, if you look at it in the light most favorable to the plaintiff, is evidence that the building knew there was an ongoing urine condition, because why would you put a sign up that says no urinating in the stairs unless you had people or dogs urinating in the stairs? You also have another piece of evidence is the porters.
You don't want to hear the question, but I got
I'm trying to answer and give you the evidence.
Well, that was a long answer to the question, but okay, here's a question I have. How do you just reconcile your arguments that you've made with the documentary evidence, as my colleague is pointing out, that 30 minutes before the incident, there is a document that says the areas are all clean?
Okay, and if you look in our reply brief, the documents you're referring to, Your Honor, are security logs. They're not maintenance logs. Those security logs were attached to the motion. There was no argument made by the
Let's back up a second, counsel. What? Let's back up a second. So there was a requirement that there was a porter who was, there were two supers. One was a live-in super, right? There's a porter at the building. There's a night shift at the building. There's a night shift maintenance worker at the building, and there's a security crew that goes around checking the buildings. So here you have your client, the plaintiff, say that the urine appeared to be somewhere between 5 minutes and 15 minutes old. Now, under those circumstances, was there enough notice given to anyone that at 1:30 in the morning, someone might have urinated and it had to be cleaned and somebody might be falling down the stairs?
There was if there was a recurring condition, and under the admission of their own witness that they produced Alpert, by the way, they knew, because he testified, who the manager was of the building at the time. He came back for a second deposition after we learned about the sign with the urine and the other things, and when he came back, he was asked, did you speak to Katrina McMillan, the prior manager? No. Did you ask her what the protocols were? No. The porter said they never kept any records.
So the porter said, Mr. Victor Rivera said that he worked from 7 a.m. to 4 p.m. He cleaned until 3:30 p.m. He did a daily inspection. There were no urine complaints.
And Mr. Alpert testified, and he was asked specifically, is this good and accepted building maintenance practice? When you know there's urine, what do? He goes, we get to the bottom of it. We rectify the problem. We put extra security. We try to figure out where the urine is coming from so we can prevent it from recurring again. That's the standard of care that their own witness testified to. There's no evidence in this record from any manager that was on at the time of the incident what actual policies
Is there
were.
a
and the
requirement,
porter-
is there a requirement that there be a maintenance worker 24/7 in residential buildings in
Not
New
under
York
normal
City?
circumstances,
Counsel-
Your Honor,
Counsel,
but-
you really have to stop cutting people off
Now you
on
got her
this
already.
side
Now
of
you
the,
got her already.
on this side.
Apologize,
No, you're doing it even now. That's not nice. We don't do that in court, right?
Well, I don't do it.
Thank you very much.
Thank you,
I thought
counsel.
you were
You have
concluding
rebuttal
with your
time.
question, Your Honor, and I apologize, and I wanted to make sure the court was aware of the facts, including the Alpert's testimony on pages 7
We got, you got,
22.
you have
that
rebuttal
really
time.
is critical to this whole thing.
Got it, counsel. You got reply time.
May it please the court. Nicholas Bruno from Michelle and Horn on behalf of the defendant.
So you got to so, okay, let's say I agree or assume that there's a recurring condition. I mean, if you have a recurring condition, that means that, well, the argument sounds like you're going to have to post someone on every floor to make sure it doesn't happen, because this urine spot that happened, it just happened. I mean, between the hours, and on top of that, I have here, even though it's a security report, a security officer, I got a report that says 30 minutes before the incident, all clear, all clean. I don't know what else to say. I mean, you know, even if it's a recurring condition, 30 minutes before, what am I going to do? I mean, you know, it is what it is at that point.
Exactly, Your Honor, and that's our contention. And under this court's precedent, under Frederick v. Nitra, which is 172, 83rd, 544 or 545, this court has held that 30 minutes is insufficient to establish.
Transitory nature, the area, the puddle is transitory, right? I mean, it's not always going to be there.
Correct. Yeah.
Oh,
Counsel, what is your response to your adversary's argument that there was a recurring condition, considering that you put up a sign that says, don't urinate in the stairways?
That is, at most, that goes to establish that we had general awareness of the problem, and that does not rebut defendant's prima facie showing that the condition was promptly remedied upon discovery, which both porters testified to. When they discover urine in the stairway, they immediately cleaned it.
Counsel, there is no record of the plaintiff or his girlfriend running to security saying, hey, he just fell, can you come and look at it, correct?
That
Did
is,
anyone run to security after this incident happened?
no, they did not. That's
And
correct.
there are 4 to 6 security officers there, correct?
I believe so, yes. If you have
Not a
nothing
trick
further.
question. It's not a trick question. You have to look on your face like it's a trick question.
If there's nothing further, I'll rely on my briefs.
Thank you.
If I could quickly just, in this court held in Brandguard versus KSSN, that a failure to neutralize a recurring dangerous condition is enough to have constructive notice, okay? So Mr. Alpert, who wasn't the manager at the time.
You know, you just said something very interesting. Neutralize a recurring condition. How are you going to neutralize someone urinating in a stairwell?
Read Mr. Alpert's testimony. He'll tell you on page 213 to 222. I will get to the bottom of it. I will find out where it's coming from. We have a secure building. We have security personnel in the lobby. This is from the second floor to the first floor. We keep an eye. Who's coming down the steps? We find out. We put up a camera. We do something.
Let's accept that argument.
And they
he
have
sees
done
on
nothing.
camera someone urinating in the stairwell right away. He calls dispatch. I'm just borrowing your analysis. He sees someone urinating on the stairwell. He calls security. Security is on its way to the stairwell, and someone falls in between.
Well, under the
What
law,
happens then?
Under the law of the Court of Appeals in Cheney, notice of a recurring condition is notice of every condition. You don't have to know.
You didn't answer my
that
question. I'm just
particular
saying,
one.
he dispatched security, dispatched maintenance. Go clean that up. I just saw someone urinating
If
on
you
the stair.
if you had testimony that this was the time they discovered who it was, but you have no effort by the defendants to find out anything. If you did that a week before and you found out who it was, and you stopped people from urinating.
This goes
in
back
the
to
stairway,
Justice
this doesn't happen. So therefore, you have notice. But
This goes back to Justice Gonzalez's comment that by your argument, you're imposing on the landlord a 24/7 obligation to have someone to monitor those stairwells. I mean, that's pretty much it, because
No, I disagree, Your Honor. What I'm asking is that if this were normal circumstances, if there were no ongoing condition, you're absolutely right. The law is clear. They wouldn't have to post somebody there. But when you have notice, when you post signs telling people not to urinate, when you have a witness testifying there's an ongoing condition, when you have maintenance records that tell them, mark urine, this is more than just...
There were 14 buildings.
What?
There were 14 buildings in
Yeah,
this.
and they have a lot of porters, and they have a lot of security personnel. They have a big operation here. So do they only need one super to be in 14 buildings?
okay, got it. Nope.
No, I'm good.
Oh, thank you. People versus Rudolph Moore. Thought I forget you, right? I didn't forget you. This one.
Good afternoon. May it please the court. Marika Meese for Appellant Rudolph Moore. This court should reduce the SORA level here to level 1 for 2 reasons. First, because 30 points were improperly assessed.
So, counsel, let me.
Yeah.
Oh, go ahead.
I'm
You're
sorry.
going to ask what I was
yours.
going to
It's
ask. No, you
yours.
go first. You first.
Counsel, even if we give you that and we take away the 30 points, isn't he still a level 2 offender?
He is, Your Honor, but he's a 75, which is the very bottom, and with the downward departure, which also is warranted, he would get to a level 1. Okay, and so in terms of the factor 1, 30 points were assessed here for using or displaying a dangerous instrument during the offense. And that was based solely on the complainant's testimony in the grand jury. That testimony established that she never actually saw a gun. There was no evidence that Moore threatened to use a gun, and that she actually lacked the ability to observe. The lighting was poor. She had horrible vision without her glasses and wasn't wearing them. And as the people conceded at the time of the plea, they could not prove that the weapon was possessed because there was a difference between what she thought or believed and what she actually saw or could be established. And although that's a different burden for the plea than at the SORA hearing, the people still didn't make out clear and convincing evidence. The people have relied on the case Coleman to argue that her belief that he had a gun could be enough. But that case is different because it's a forcible compulsion case, and it doesn't have to do with the displaying a dangerous instrument element.
Let me just say, let's cut to the chase. Let me say, let's say I agree with you, what you're saying, the 30 points shouldn't have been assessed. Now we're at 75. Why was an abuse of discretion for the SORA court not to grant the downward modification, the downward
Departure,
the level 1?
First, the court applied the wrong standard. The court applied the more onerous, clear and convincing standard.
Yeah, but he corrected that in his writing, if I
The written decision does use the correct language, but it doesn't explain the disconnect between the actual decision made at the time, which is when the level was imposed, and the later decision. And so there's no evidence that the court actually applied the correct standard. So at a minimum, I think this court could remand it for further proceedings before the trial court. But in any event, the court found that the grounds on which Mr. Moore sought a downward departure weren't proven or weren't proper.
Because the people wanted an upward departure.
They did, and the court denied that, and that issue is not before this court because the people never appealed that. But
I just want to clarify
Yes.
that both sides wanted the departure.
Yes, they did. But here, even though the RAI does account for certain of the factors, it didn't fully account for the mitigating circumstances or adequately do so for Moore's unique circumstances. I see that my time is up, but I can finish that argument on rebuttal. Thank you.
Your Honors, may it please the court, Jonathan Sklar for the people. Your Honors, defendant is lucky he's not a level 3 offender. He has a history of sexually grotesque conduct. Just 6 years ago, he broke into this woman's apartment and he forcibly raped her with her mother and her 10-year-old sister in the other room. In 1998, he broke into another woman's apartment, dragged her by her hair to the bathroom, touched her breast and vagina.
He sexually assaulted her too, right?
Correct. And in 2003, he masturbated outside of a woman's window and exposed his penis to her. So he has a history of of this conduct, he's a high risk of reoffending, and obviously the harm would be very grave. So,
Well, at a minimum, he doesn't deserve a downward departure. You're not appealing the denial of the upward departure, but you're saying the downward departure based on this. The court didn't abuse its discretion when it said, no, I'm not giving it to you.
correct, Your Honor. There's absolutely no basis for a downward departure here. And if you have no other questions, I'll rest on my brief. Thanks.
Thank you.
Counsel, would you address the mitigating factors that you believe the court overlooked and that the board overlooked? Because I'm
Yes, Your Honor.
curious.
Yes, well, the factors that Mr. Moore relied on were, one, that although he did not have a prior sexual offense, he was assessed 30 points for having a prior violent offense. The RAI accords the same number of points for either. But here, his prior offense was 12 years ago, and so we believe that that's a mitigating factor because
There were two robbery one convictions, and each of them was a violent felony, right?
Correct, and although that can be a proper assessment of 30 points, here the RAI didn't fully take into account that for Mr. Moore there had been a substantial amount of time and he had done successfully on probation and parole every time that he was placed, and here his supervision sentence was another one where he would be likely to succeed. As well, his strong family support and living with his sister, which was supported by the letter he submitted, provided the kind of evidence that has been shown statistically to greatly reduce the risk of sexual reoffense. And so for those reasons, especially when he was on the cusp, we believe that a level 1 is appropriate. Thank you.
Thank you very much. Cheney versus Fulton Jefferson Housing. Justice Gonzalez is just recused herself from this matter.
Jeffrey Van Etten, Perry Van Etten, Rosansky, Kuttner for Fulton Jefferson Housing Development Fund Corporation, a not-for-profit corporation, and their management company, Phipps Houses Services.
That doesn't make them any less responsible.
Sorry?
Do you?
No, it doesn't make
The fact that they don't make a profit, right?
No, actually, the facts of the case and the law make them less responsible. In this case...
Wow, that's what you're arguing.
Absolutely. In this case, Judge, this is a clear-cut case where my clients are a landlord. They had a tenant that had a dog. They know the dog. The two prerequisites in establishing liability with a dog bite case, one, that you know of it, two, that they know of the vicious propensities.
Well,
But weren't dogs
also...
I'm sorry. Weren't dogs not allowed?
That was a policy. That was a policy not used. And as it states in Carter, which is in the papers, that does not matter. If you don't follow that policy, that has nothing to do about determining vicious propensities. Carter's there, First Department case. So what are the vicious propensities? Both the porter and the superintendent on duty and porter every day there, say they never were aware of this dog having vicious propensities.
What about the plaintiff's daughters, the two of them, who said, no, we told these guys that that dog growls and barks and scratching on the door and all that kind of stuff?
And that would be the feigned affidavits that were actually put in opposition to summary judgment. And the issue that I...
Oh, you can say that about every affidavit. It's feigned. Come on.
True.
I mean, you're gonna ask us to pick one over the other then, right?
Well, when the plaintiff gives a discovery response in their bill of particulars on notice, record page 81, that the actual notice was by Gamba, who never was identified, or it was given to the management office as well as the building superintendent by her, nobody else. Plaintiff's discovery response did not identify these individuals. The affidavits themselves are almost verbatim, the exact same language, including the one daughter who doesn't live in the building, saying that I felt myself as a tenant and others, stole the language from the other sister. They copied the language, they put it in. Why? To defeat summary judgment. Because they could not overcome the fact there was no evidence of vicious propensities of this dog. I mean, we're talking dogs, we're talking animals. Dogs have different characteristics.
What kind of dog was this?
The plaintiff claims it's a pit bull by its color and its heft, though she wasn't sure. But even that doesn't matter. There's case law that says just because it's a pit bull, that doesn't mean it has vicious propensities. You have to show more. Plaintiff never showed more. And what the court did correctly state, defendants had made out their prima facie case that they didn't have notice. So the only way that plaintiff overcame, because
So
herself.
what was your reply in terms of the two daughters' affidavits? What did you, what was, I forget, what was the reply, what was your response to that? Other than saying that, you know what, these are feigned affidavits, did you have?
We make a motion for summary judgment, discovery's closed, they have the affidavits of the daughters. What it comes down to are those, that the court tried to say that was going to be a credibility issue. Had they identified an actual person they spoke to, had they identified, unlike the mother, the telephone number that they called, had they given the dates in which these supposed calls were made, had they, if they were opposing it, put in the phone records verifying they actually called. In the one affidavit, they even just said, I told building management. Didn't say where, didn't say how. I mean, neither daughter said they told the building super or porter, even though that was what was originally alleged. That's why we know it's a feigned affidavit solely for the purpose of defeating summary judgment.
Okay. Thank you.
Thank you.
Good afternoon, Your Honors. Jason Firestein from Zlotto and Associates on behalf of the respondents. So a year prior to the summary judgment motion being made, disclosure of the notice witnesses was provided. It was in their moving papers. It was disclosed in February of 2021. The note of issue was filed in 2022, and the motion followed. There was no attempts by the defendants, despite being given notice of these witnesses, to depose them, even ask us to produce them as
You're
witnesses.
saying that the daughters were disclosed?
It's right in the record on appeal, and they put it in their motion papers. They were disclosed a full year
They
before
never
the motion
took
was
their
paid.
deposition.
They never did depositions. And Johnny Cheney herself, you know, this is, first of all, this is a 70-year-old woman. It's a walk-up building. So you walk up, and each floor has a couple of apartments there. And she lives on the very, very top floor. You know, she herself, and it's on page 134 and 135 of the record on appeal, said that she contacted building management by phone because the porter and the super, they don't give out their phone numbers. They put that in their testimony, leaving a message saying, by the way, there's a dog here. I don't like the way it looks. And it's interesting that counsel for the, you know, the appellants now acknowledging that there's a policy of no dogs in the building. Betancourt, the superintendent, was there years. He has no idea about that. Araz, the porter who testifies, says, yes, not only does everyone know there's no dogs in the building.
Yeah, but they're conceding that, okay, that policy was violated. The question then becomes whether or not they had notice of the vicious, alleged vicious propensities.
Right, well.
And he's taking apart, or he's challenging the two daughters' affidavits saying that they're feigned because that was the only way they could avoid getting summary judgment against them. And because they weren't, we didn't know that these daughters existed. But you've pointed out in the record, hey, look, they're there. You didn't do it.
They're there, he didn't do it. And listen, under the feigned affidavit, I mean, Johnny Cheney herself said she made a phone call. And they didn't ask Johnny Cheney in her deposition, which you can see is it's only 50 or so pages long, about her daughters, whether anyone else complained, whether she had knowledge of their complaints or anything like that. You know, Carthen, you know, the case of the feigned affidavit, which says that on rare occasions, when you're talking about non-parties, people who are not parties to the litigation, you can look at their affidavits as being feigned when it completely contradicts a plaintiff's testimony. But Carthen tells the court to be circumspect in that and use it on only rare occasions. So here, it's not only not contradictory, because Cheney herself mentions that she complained about the pit bull to management, but the daughters who visit her and who walk up those same steps and see her complained about the dog to building management. The porter and the super, they have 4 buildings. They're there on occasion. But what's interesting is they put in this incident report, unsworn incident report from a building manager who learns of this dog bite. You know, there's blood on the steps. She learns of the dog bite. And then, you know, if there's a policy of no dogs in the building, why didn't she investigate it? They had every opportunity to contact the tenant, go to Unit 4C, find out who lives there, find out if they're harboring a dog there. So there's no evidence of that. Listen, they may have great arguments for the trier of fact about the relationship and the affidavits, and they're just supporting their mom, but that's what a trial is for. And that's why summary judgment was properly denied.
Thank you.
Thank you.
What may or may not have happened post-incident on investigation is irrelevant to, again, what happened before. The plaintiff's own testimony, the record 134, as to what she supposedly left a message. Didn't speak to anybody, just left a message, if it was to building management. There was a dog in the building looking vicious and stuff. Looking vicious and stuff does not put somebody on notice of vicious propensities. Okay, as we said, with dogs' characteristics.
You know, you can sit here and argue until the moon comes up on that one.
Judge, there has to be more.
I don't know how you want to interpret vicious.
No, the case law says there has to be more by the actions of the dog, not looking vicious. Somebody can look a certain way, and that is a judgment call. That doesn't put us on notice that there is a potential danger or hazard to somebody in the building. That's what it is. I mean, I don't like to use the example, Judge, but I have a dog that every night I come home, he smiles at me, but he goes like that and his gums go up. People might think that's baring teeth. He's happy to see me come home. Okay, so to say that puts you on notice, that's insufficient. And just because of some of the humor earlier and some of the more seriousness, I'll say this. The Pink Panther movies, Inspector Clouseau asks an innkeeper, does your dog bite? The innkeeper goes, no. He goes to pet the dog bites him. And he goes, I thought you said your dog doesn't bite. And he goes, that's not my dog. It's not our dog. We had no notice. We cannot be liable under the precedent before you.
Okay, thank you very much. JD2 Realty versus EvoJets. Welcome back.
Good afternoon.
Good afternoon.
May it please the court, my name is Guy DeRosier from Wilson-Elser, representing the plaintiff appellant in this case. I know my time is limited and the court is familiar with the facts, so I'd like to simply raise a couple of points, and with a little bit of luck, I may be back in my seat before the red light goes off. The first point I want to raise is that both contracts in this case contain an exculpatory clause, which defendants claim absolves them of any liability if the return flight was delayed due to a mechanical failure. Now, they both moved to dismiss on that ground, but they didn't include any documentary evidence to show that there was, in fact, a mechanical failure. And the court would look in vain for any...
Right, the only thing they had was an attorney affirmation, and I think from an affidavit from an employee with no personal knowledge of exactly what happened.
Ms. Marin's affidavit, which was offered on reply.
That's correct, Your Honor. First of all, it was offered in reply, and we objected to that. And what's kind of funny is that the court, at the end, considered the affidavit and wrote in the decision that we failed to rebut it, even though it was submitted in reply and we didn't have an opportunity to rebut it. But be that as it may, the affidavit itself did not refer to any documentary evidence. It simply said, I'm an employee of, and I'm paraphrasing here, obviously, of the company, and the flight was delayed due to mechanical failure. Without any further explanation. So we have essentially a statement made under oath versus an allegation in a verified complaint. Sadly, the complaint itself is not in the record either because nobody submitted it, but the court can take notice of it through NYSIF documents.
Counsel, can you speak to the forum selection clause in the MJS contract?
Yes.
Aren't you bound by that?
Right. There are two form selection clauses. One in the brokerage agreement, which favors New York law and uses the word exclusive, and there's another one in the Florida contract, which is the charter agreement, that does not include the word exclusive, but refers to the courts of the state of Florida. So our argument in our main brief was that essentially the court had a choice here between the two, and there was no reason to favor the Florida one because the Florida one is permissive, whereas the New York one is clearly exclusive. And we had argued as well before the Supreme Court that even under Florida law, there are exceptions if the application of the forum selection clause would result in splitting of a cause of action or multiple lawsuits, which would be the case here. So we took the position that the court had no reason to dismiss this action based on the forum selection clause.
Doesn't it say the venue shall be in Florida? That's not enough, it's not emphatic enough?
Especially if you're going to argue a third-party beneficiary of that contract. If you're a third-party beneficiary of that contract, you'll be bound by the contract, right?
Well, we did argue that we're a third-party beneficiary because...
Right, so you're stuck with it.
Right.
Shall means shall. I mean, there's like a lot of interpretations of words today. But I think shall we can all agree on means you got to do it.
Well, shall, but there are, I mean, it
Oh, now we're
means-
going to get another explanation. Shall means something else.
Counsel, would you address your position that your client is a third-party beneficiary of the contract between MJS and EvoJets?
Sure. Well, under the clear language of the brokerage contract, first of all, it says that EvoJets is simply acting as the agent for the purpose of negotiating and executing a charter contract. The charter contract itself was performed directly in favor of my client. And New York case law does say that a good indication that someone is a third-party beneficiary is if performance is made directly to that person, which is the case here. I mean, the little evidence that we have in the record does show, and this is not disputed, that the only passengers on that plane were members of my client and their guests. The other point I wanted to make very briefly is that the contracts also contain a limitation of liability clause. And the argument that the defendants are making here with respect to that is that they're saying essentially, well, if you want to override the limitation of liability clause under New York law, you have to show conduct that amounts or smacks of intentional wrongdoing, and your complaint just doesn't do that. But that's a false argument because, first of all, it doesn't take into account the fact that even if if the liability of their clients is limited, we're still entitled to something under the contract. Some money was paid and some money should be returned. Now, we're not conceding that, the limitation of liability clause is enforceable, but the fact that our client's recovery may be limited does not warrant dismissal of the complaint outright. And that's the point that we're making. So essentially that there's no reason for the court to dismiss this action based on the limitation of and I'd just like to point out, if I may, in just 10 seconds or so, the electron trading.
Don't rush. You have rebuttal time.
Okay, thank you.
You don't even need 10 seconds. Thank you.
Good afternoon, Your Honors. May it please the Court, Riaz Bibani, Eckert Siemens, Chairman Camelot, for Respondent EvoJets. The lower court dismissed the case on...
You have an affirmation from an attorney without any documentary proof, and you have the employee, Ms. Marin, coming with an affidavit that's on reply. I mean, you kind of sandbagged the other side when you did that, right? I mean...
That's not my affidavit. That's not my client's affidavit. My client is EvoJets.
This was Jet Savers?
Jet Savers had the chance to fully brief their motion.
My mistake, my bad.
That's okay. And yes, it was done on reply. But if you look at the procedural breakdown of how the motions played out, my Jet Savers makes a motion on contractual language.
Right.
And then...
Between you two. Right.
No, it's not. We did not move against each other. Both motions were...
No, but the contract was between you and her, I mean, you and...
Our clients, yes.
And my jet, right? To get the jet.
So my client's EvoJets, and my Jet Savers moves first. And their motion is fully briefed. Then EvoJets makes their own motion.
Right.
The original motions were made on the contract language.
Right, mechanical issue. It's basically, right?
Hang on, the mechanical issue comes up in opposition, in the complaint, and then in opposition when he's like, oh, well, you have all these language provisions that you're trying to enforce. Makes sense on a motion to dismiss, but you actually rebooked your flight to a higher paying customer. Whoa, hold up there. It's raised in your complaint, and now we address it on reply. That's the mechanical issue. That's how I see the My Jet Saver motion playing out. Then on the time that EvoJets gets to make their motion, the motion is made to dismiss because there was another action pending, but also because of the exculpatory clauses. And so then as it plays out, the issue comes to the forefront. Well, what was the reason why the flight was delayed?
Why do you think, just give me your argument as to why do you think you're entitled to summary judgment?
It's a motion to dismiss.
I mean, I'm a motion to dismiss. Why are you entitled to to an affirmance of that? Because
Well,
the
from
court just dismissed
EvoJet's
it, right?
perspective, there is a contract. It is enforceable. This is what is contemplated under 3211.
But there's a central question here that you just raised, which is why was this flight canceled, right? And I looked in the record, but we don't have anything dispositive, first of all, as to who canceled the flight. Am I right? Was it the broker or was it the airplane operator?
So I want to operate within the context of this contracts because that's what we're doing on a motion to dismiss.
But you need to answer my question.
Yes, I am, and I am. and so the flights were canceled because of the mechanical issue.
No. Who canceled the flight? Or what canceled?
I don't think that that question is particularly answered on the record as to who did it.
So there's no answer to that.
But my client is just arranging the flights. They're not operating the
So
flight.
why isn't discovery needed? Why is this motion to dismiss not premature?
Because I don't even think we need to get there because there's not going to be any question. The reason why you make a motion to
Question as to who canceled the flight?
it wouldn't matter because the sum answer is because of the mechanical issue. And that would be beyond my client's control, which would
know that.
Because under the agreements, EvoJets books the flight for the passengers.
Yes.
And then
But one of the allegations by the plaintiff is that the flight was canceled so that somebody with more money could get a chance to fly. And this is, of course, during the pandemic, and it's mostly near New Year's, right? So doesn't the other side need to have an answer? Doesn't the court need to have an answer?
I think the question was answered in the lower court because there was a period of time amidst the briefing and before oral argument where the records were handed over to the plaintiff's counsel.
So do we have an affidavit that says, I did it?
We have the affidavit from the lawyer who handled EvoJets' motion on reply saying the documents were disclosed. And then you have a comment in the judge's decision saying that the records were disclosed. So it's my perspective that the judge who was presiding over the motion had a holistic approach to it and says, this is what it is. So I think it wasn't necessarily a sandbagging operation. I think that it was all kicking up, and it certainly was addressed at oral argument on the motion.
Okay, thank you.
Thank you.
Good afternoon, Your Honors. My name is Angelica Zolnierowitz. May it please the court, I'm here on behalf of defendant respondent MyJet Saver LLC. Your Honors, on January 3rd, 2021.
Look, the way I look at it is that you have two contracts here. You have a contract between EvoJets and the plaintiff, and then you have a contract between EvoJets and your client, right? So,
with EvoJets and MyJet Saver, yes.
right. So the EvoJets contract with the plaintiff says that they're not going to be liable if there's a mechanical difficulty or a breakdown of the aircraft. That's what that contract says, right? So if you peel it back, they're going to, that argument or that defense is dependent on what you're going to say. Because they're not going to, as he said, and I listened carefully, he says, look, we don't supply the aircraft. We're just the go-between. It's MyJet is the one that supplies the aircraft. So that defense is dependent on what you're going to have to produce and say.
MyJet Saver does in fact, and did in fact provide the aircraft. The first flight did take off as planned.
That's not the problem. It's the second flight that we got a problem. So what did you show, or how did you demonstrate by documentary evidence that there was a mechanical issue or a breakdown of the aircraft?
The flight records were provided to EvoJet, and then from what I do know, Your Honor, what I did learn is that they were also then provided to plaintiff appellant, to the former attorney of EvoJet.
So those flight records actually said and documented mechanical failure in the very document themselves. Why weren't they attached to your motion?
Your Honor, as counsel for EvoJet did go ahead and say, it just so happens as to the order of where the motions were submitted, where the document requests were made, and et cetera. And then also, we do have, so Maria Marin, she is the corporate representative. She's CEO of MyJet Saver. So
It's not documentary evidence, though. It's not business record. It's not documentary evidence. An affidavit is not documentary evidence, correct? So you can't say that the motion to dismiss is based on documentary evidence if it is based solely on Ms. Marin's affidavit. You'd have to agree with that, right?
That is correct. The records were provided, but following that, yes.
But they weren't attached to Ms. Marin's affidavit.
They were not attached to Ms. Marin's affidavit, no. They're provided after the fact.
Them. We can't base a decision on something that hasn't been provided to us, right?
They are not in front of the court at this time, but they were provided to the Supreme Court. They were part of that case.
So if we look in the, is there a reference to that in the electronic filing system?
There is a reference that the Supreme Court judge, he did go ahead and in his order.
No, to the records themselves.
I'm not aware of that, ma'am, Your Honor.
Okay, thank you.
Just to clarify, I've seen no indication that the trial judge looked at or ever saw these records. The only reference to them is in this reply affirmation from former counsel to EvoJets saying basically these records were provided to plaintiff's counsel. That's it. No one attached them to anything. They were not before the court. There's no indication that
Even when the counsel said these records were attached, but there were no records.
There were no records. There were no records.
It's a conclusory statement in a sense, right?
Right, and whatever counsel's description of what those records might say is pure hearsay.
I'm just curious that, thinking out of the box, when you're dealing with aircraft, I mean, there's so many FAA rules and regulations. When you have a mechanical breakdown or some issue with a jet, that's got to be logged somewhere. I mean, there's no way that that's not logged somewhere. I mean, it's pretty easy to, I think, obtain.
One would think. So, I mean, especially we're at the pre-answer stage, let this play out on discovery, and if the records are there, I'm sure they'll come out, and then a decision can be made based on what the records actually say or don't say.
Okay.
Thank you.
Okay, thank you. Navaro versus University Avenue.
Good afternoon, Your Honors. May it please the Court. Matthew Corcoran for Defendant Appellants, University Avenue. Very briefly, I would like to start by just addressing Justice Ramirez's order where she found that we did not offer information from somebody with personal knowledge of the facts of this case. I believe respectfully they were just mistaken. We offered the testimony and affidavit of Jose Serrano, the building manager, who attested to his inspection schedule, who attested to the lack of notice, and who attested to what the scene appeared after the accident when he came about 5 minutes after he was notified of the plaintiff's fall.
There was nothing in this record that showed that there was a light on and functioning at the time the plaintiff was asked by his boss to go down and empty a bucket of water, correct?
Well, that is true, but...
And the record does show that the light switch that he was attempting to try and reach for didn't exist on the upper portion of the stairwell, but it was somehow in some locked unit, for want of a better word, at the base of the staircase, correct?
It was in a locked unit to make sure that nobody could turn it off so that the situation did not happen.
I'm sorry, Counsel, you're speaking very quickly. Could you say what you said again?
Sure. It was in a locked box in the basement to ensure that a situation like this did not happen so that nobody could turn it off and leave the basement staircase without lights. But even though there's nobody who testified that the lights were on at the time of the plaintiff's accident, we still do have a lack of notice here. There's no evidence in the record. Plaintiff himself had never been in this building before. He testified he had never gone into this stairwell before the time that he was instructed to by his supervisor to go into the basement stairwell. There was no notice from anybody else. Our person testified he had never been notified of any complaints about the basement staircase lights being out.
So, Counsel, the fact that there's no light switch, if the facts are that there's no light switch and that the light switch is in a locked area, as my colleague was just stating, then if the light's off, what kind of notice would you need? There's
Well-
no way to turn it on, there's no way to turn it off.
Just to also offer this, there is an emergency backup set of lights in the staircase as well. So if the primary set goes off, our witness testified there's an emergency set as well. The notice that would be needed is that we would need somebody to say, we don't know what happened, but the lights are off. Somebody needs to go into the basement and address the issue.
From someone who said that the lights were on when they found him?
When my client went to the scene after the accident, yes, he said the lights in the basement were on. The lights in the staircase were on when he came on the scene. We also have some interesting contradictory testimony from plaintiff himself that suggests the lights were on when he was found.
Contradictory testimony means no motion for summary judgment, right?
Well, allow me to clarify, Your Honor. Self-contradictory testimony.
Are you
Sorry.
referring, I'm sorry, are you referring to the fact that when he was at the bottom of the stairs, he allegedly saw the faces of people around him, which suggests lights were on?
That and testimony from before his accident. He says that he opens this door and he claims pitch black, can't see the floor, can't see the stairs. But, and this is on page 125 of the record, he also was asked, when you opened the door, did you see a handrail? He responded, yes. What side was the handrail on? It was on the left-hand side. He even testified that he moved the mop bucket that he was holding from his left hand to his right hand because...
Well, back up though, that testimony is within a greater context, right? He felt for the light switch, didn't feel a light switch, then transferred the bucket, and then felt for the handrail, and boom, he fell.
Well, he transferred the bucket first, but he still also testified that he saw the handrail when he opened the door.
Well, that could have been reflective of where he was before the door opened, correct? You could have saw a little light.
Possibly.
And there's also the possibility that even if the stairway was pitch black from the pictures, I was able to attempt to try and circumstantially infer that maybe after he landed, and I think there was some information in the record that he may have blacked out. I don't remember right this second, but there was something along those lines. And having seen faces around him, isn't there a door with a window at the bottom of the staircase that actually goes into the laundry room for the building?
That's correct, and light comes through that window.
And if the light were on in the laundry room, in that little circle, from what I saw in the photographs in the record, perhaps that could have given some light. It certainly would not be lighting the whole stairway going up and down, but it may have shed some light at the base of the stairwell where he may have had the ability to see faces. Would that be unreasonable?
Well, it wouldn't be unreasonable, but that's an interesting point that you raised, Your Honor, because two of the photographs that were annexed to Mr. Serrano's affidavit depict the stairwell in exactly that condition. The immediate stairwell lights being off, but the lights from the laundry room continuing to be on, and he says this is an accurate portrayal of how the staircase looks. It is not pitch black, as you can see in the photographs. I believe there's 7 and 8 to Serrano's affidavit.
Yeah, I'm looking at 334 and 333 as well. The interesting word, or the word that comes up again and again in the oral argument today is possibility. We keep talking about possibility, possibly this way, possibly that way. Contradictory. How are you entitled to a summary judgment, the granting of a motion for summary judgment?
Well, using that very word, possibility, I'll use a sort of a synonym, speculation. There's absolutely zero evidence in this record as to how long the lights would have been out. This isn't like a crack in the sidewalk, a condition where you can discern from the condition itself.
Isn't that the jury's role to determine what credibility they afford to the witnesses and what credibility and how they view, what weight they give to the photographs?
Well, not necessarily, Your Honor. I'd point you to the case of Rivera versus 2160 Realty Co. on page 13 of my brief, where there is absolutely no evidence in a record as to how long a condition may have existed. The Court of Appeals has decided it would be speculation. It would require a jury to engage in speculation to determine that it existed for any appreciable period of time, 10 seconds or 2 hours. Sorry?
He did testify that it was black, no light.
Okay, you can think about that on reply. Thank you.
Thank you.
Good afternoon. May it please the court, George Ilkert of Hack and Rose for the plaintiff respondent. I will be brief. The only evidence...
He opens the door, it's dark. I can't find this light switch because the light switch we know is locked somewhere else.
Right.
Grabs the handwheel. That's it.
That's exactly it. Whatever existing light
As my
may have been
colleague said,
ambient
whatever
light.
ambient light you have, I mean, that goes to whether or not it's a trial fact, whether or not it was sufficient, with the ambient light. That's about it, right?
That's it, Your Honor.
Okay. Thank you.
I'll just raise one brief point on rebuttal. We do have one argument in our brief that also says plaintiff is required to exhibit an element of common sense where there's an open and obvious.
That's comparative fault, though. I read that. I mean, that also goes to whether or not he should have proceeded in the face of whatever he saw. I mean, who knows? I mean, he might have been. I mean, work's work. He's delayed and he's not going to get paid. Who knows? I mean, that goes all to comparative fault, whether or not he should have continued down his road. All we know is, just based on the facts that we have, the deposition is that he opened the door, it's dark, he's trying to feel for a light switch, we know is not there, tries to fiddle with, and let's not forget the age of the individual. He tries to reach for the handrail, and next thing you know, he takes the slide down the staircase. That's about it.
To that, I'll just say that the cases that we cite on page 12 of our reply brief, those cases that say that a plaintiff has to exhibit reasonable care in an open and obvious condition, they awarded summary judgment to the defendants. They didn't go to comparative negligence. But unless there are any other questions, I'll rest on our papers.
Okay, thank you.
Thank you.
Patterson versus City of New York.
All right. Good afternoon, Your Honors. My name is Alan Patterson, pro se. This should be one of your easiest cases for the day, since y'all said y'all had read through the briefing, all my evidence.
Yeah, you've been up here before.
Yes,
on a prior
I
case.
did. Yes.
And I was there too. I
Yes,
sat
for that
over
one.
on the corner, I think, way back when.
There was a letter dated July 20th, 2023 from the City Law Department, Patterson versus the City of New York, case numbers 2023-02777 and 2023-02793. And it states, to the Honorable Clerk of the Court, this office represents respondents in the above reference appeal. Petitioner, appellant appeals Supreme Court's denial of his motions to renew. Because respondents did not file oppositions to those motions in Supreme Court, they will not be filing a brief on appeal. To the entire panel, I unanimously request reversal of Judge Bannon's ruling. As you can see, respondents, City of New York, never opposed my new evidence in lower or intermediate court because it's a smoking gun that debunks every myth and lie by the New York City Administration for Children's Services and the New York City Civil Service Commission. Since this Article 78 came to existence, there is now nothing for them to contest, which is why they are not here at this moment. This was always an open and shut case. I never was terminated from ACS, as they had falsely stated I was terminated on September 22nd, 2016. I resigned on August 22nd, 2016. And these new exhibits that I never knew existed, never was given to me as discovery in 2016 when I had to deal with the Civil Service Commission, nor in 2017 with the Supreme Court, Judge Nancy Bannon. Throughout those time periods, all these documents existed, and they substantiate all my arguments, which is CPLR 221E2. I implore this entire panel to personally read my brief again and not your assigned clerks. This court now have computer evidence with input data from drop-down menus confirming I resigned, and it states in those drop-down menus that's on computers program, it states employee separation by termination, by resignation. And emails from ACS acknowledging that I resigned on August 19th, 2016. They're declaring it. Even the ACS agency attorney who was prosecuting me for the false misconduct charges, he even stated in an email that I resigned. He states the date that I resigned, that a penalty decision is moot. All these are in exhibits C, E, X1, X2, and Z. Here's why Judge Bannon's decision is unequivocally correct. Both lower and appellate court have Exhibit C, Patterson's immediate resignation, which is statute 4 NYC RR 5.3A, and it was accepted and timestamped by ACS on August 19, 2016, making it statute 4 NYC RR 5.3C, which is all the proof needed that Patterson resigned and it was accepted by ACS and it's irrevocable. But since Judge Bannon refuses to comply with state law, common sense, and binding authority from the New York Appellate Courts and the New York Court of Appeals.
Patterson?
Yes.
Did you resign while an investigation was pending?
Yes, I did. No, there was no investigation pending. I resigned after prosecution of misconduct charges. The whole oath proceeding already took place, and I resigned once I have obtained a new job. That statute 4 NYC RR 5.3B states that if an employee tries to resign while misconduct charges are pending or about to be filed, and that's his way to avoid having the charges prosecuted, the agency can say, no, we're going to disregard your election to voluntarily resign, and we're going to move forward and proceed and prosecute the charges. I resigned after prosecution of charges. That statute no longer applies to me. How can you go and it clearly states, and it's right here, I printed it out too. If charges of incompetency or misconduct have been or are about to be filed against an employee and the employee submits a resignation, the appointing authority may elect to disregard the resignation and pursue the charges. I resigned after charges were prosecuted against me. They accepted it. They accepted my resignation. They told me I was no longer an employee. You have the computer printouts. You have even the HR department with them with the dates. They lied. It was the Silver who brought this whole statute 4 NYC RR 5.3B into play was the New York City Civil Service Commission. If you look at the oath reports, just like I had stated in date on the oath report, you see the dates of prosecution. They were in April. They were in February and April of 2016. I resigned all the way in August of 2016. Went through the whole entire oath process.
Thank you, Mr. Patterson. We'll look at the record. We'll take a look at everything. Thank you again.
All right. I just want to say one more thing.